In responding to this question, it is important that we revisit briefly the different types of marriages that the law recognizes. The law makes provisions for three types of marriages. The first type of marriage is what is called a valid marriage. A valid marriage is the marriage that has the blessing of the law. This is a marriage that is recognized to be legitimate. The other type of marriage is what we call a voidable marriage. A voidable marriage is a marriage that one party, if they so wish, can use something that is mitigating to get out of that marriage. We have touched on this type of marriage when we mentioned the case of Dennis versus Dennis, where a woman challenged successfully her marriage on the basis of penetration, and the law defined what is the acceptable range of penetration and what is the acceptable size of manhood to consummate marriage. The third type of marriage is what is called a void marriage. A void marriage is a marriage that is empty. So if you are to marry an individual that is of unsound mind, it doesn't matter how old they are, the law says that their mind is unfruitful to furnish consent. So that makes this type of marriage to be void. We had said void simply means empty. So having understood those types of marriages, where do you think this question falls? This question falls in a very unique area of marriage that most of us confuse. The difference between cohabitation and presumption of marriage. Cohabitation and presumption of marriage, they have the same features, but they are worlds apart. So at what point is the arrangement you have between a man and a woman cohabitation? At what point does what you have between a man and a woman, at what point can the law recognize it as that one is presumption of marriage? These are the elements that the Supreme Court of Kenya advanced to help us distinguish that if you are in a union and that union has these 8 features, then that one, presumption of marriage, can extend to. Presumption of marriage is a marriage that is recognized under the law. And it is important for us, particularly in addressing this question, because this question deals with at what point, if you understood this question better, at what point does a man and a woman merely cohabiting? At what point is a man and a woman having presumption of marriage? And the court said that there are 8 fundamental elements that must be met in order for presumption of marriage. This marriage merely deals with the presumption of marriage. The first element is 1, that parties must have lived together for a long time. So that is the first instance of a presumption of marriage. So originally, the presumption of marriage kicked in after 3 months, kicked in after 6 months. But now the position that has been reviewed is that there must be a longer duration. So this is whereby the court failed to give us what is the acceptable margin that would pass for long duration in marriage. The second one is parties must have legal right or capacity to marry. So in order for you to claim presumption of marriage, you must have that capacity. Capacity means you must be of the right legal age. 2, you must have entered into it consensually. And 3, that marriage must not possess any mitigating factor. So the legal capacity is very important. The third consideration is parties must have intended to marry. And this is where it gets sticky. Because where do you divide the line of intent? How do you know that this individual has intended to marry you? So the intent in this instance is purely circumstantial. So the intent might be, has the gentleman introduced you to his family, for instance? Has the gentleman gone to your place, or the lady taken you to her place? So these are the circumstances around which we are now going to make inference on the intention. I think we remember lastly when we talked about the difference between motive and intent. Motive and intent are motive and intent are two things. Motive and intent are two words that are diametrically. Motive and intent are two words that are diametrically opposed to each other. In law, we are constantly interested in intent over motive. So whenever we want to look at, and I would invite you at your own time to look at how the Supreme Court of Kenya has distinguished a presumption of marriage, the most important thing, and this is what I wanted us to get out of this, is the intent on the parties to be involved. So that intent is circumstantial. If you have lived with someone for 3 years and you are blessed with fruits of that engagement, and in the process of you getting a birth certificate, the guy withholds his name from that birth certificate, then we can make an inference that the intent to be married to that gentleman does not exist. So this question dealt with that so that we understood the different types of marriage. And in Kenya today, presumption of marriage is alive and well. It kicks in when a marriage or a union between man and woman has met those 8 requirements that the Supreme Court of Kenya had put. Where those 8 requirements have not been met, then marriage does not exist in that union. And if a marriage does not exist in that union, we can make inference that that is just an instance of cohabitation. So that is how I would respond to this question. And I really want to hope that I have responded to this question to your satisfaction. If there is anything that you might want me to touch on, kindly don't forget to leave it in the comment section. And I want to thank you for having raised this question, and I want to hope that we have learned on how we can distinguish 3 of the most recognized forms of marriages under the law. My name is Ogwang, and I will see you in the next one. Until then, take care, God bless, and bye-bye.